Hillary Walsh, immigration lawyer at New Frontier Immigration Law. I'm so happy that you're here with me today because I have some breaking immigration news to share with you that is so good for immigrants that it couldn't wait another day. We have some wonderful updates for you today. So the person that this impacts the most is going to be someone who entered the US and left. They were here for a while, they left, and then they re-entered the US with a visa or something related to that, like maybe they were waived through. So if you are someone who has what's called the 3 or 10-year bar, you were told that you need to be out of the country for 3 or 10 years in order to fix in the United States, this is a great video for you. And I see everybody already here. I want to say hi to you. And Hagar Haran, it's good to see you. And we're going to get started. So here's what I have to show you today. This is a class action. It's good to see you, Gurkaran. I'm happy you're here. This is what's called a class action. It's filed in the state of Washington up north. And it applies to everybody who's here in the Ninth Circuit, which Arizona, California, Nevada, Washington State, Oregon, we're all in the Ninth Circuit, in Hawaii too. So while this case was only filed in Washington State, it applies to all of us here. It also is very helpful for other judges in other jurisdictions to be able to see as well. So no matter where you live, this is really helpful for you to see. So here we go. This is a class action. Let me tell you what a class action is. A class action is a group of people who are similarly situated having the same legal problem. You can join together as a class and file an action, a lawsuit. You can sue the government all together at one time. The benefit of being able to do this is the attorney just has to make the same argument for all these different people one time. You can basically pitch in together and hire one abogado to be able to help you, or abogada. In this case, the attorney is a nonprofit called Northwest Immigrant Rights Project up in Washington. And Matt Adams is a fantastic attorney who I've worked with on Supreme Court cases, and I think he's pretty fantastic. So let's look at this. This is on behalf of all these plaintiffs, see if I can work my mouse, against USCIS. And here's what's important, is there's a discrepancy between what the immigration law says and the way USCIS is adjudicating petitions. Here's a very real world example because you can kind of see the problem. If I'm in the United States, let's say I'm Mexican, I enter the US on a tourist visa and I overstay. I overstay by 180 days, by 6 months. I was here. It was really great. I thought perhaps I was going to stay forever. Maybe I was going to get married. Maybe I wasn't, whatever. And I ended up leaving. Going back to Mexico. I'm there for, let's say, 18 months. I need to renew my tourist visa, let's say. And then I come back into the US. Well, now, fast forward 20, 25 years, and I have a US citizen son. He's 21 years old, and he wants to petition for me. I go to an immigration lawyer and they tell me, I'm really sorry. You have what's called the 10-year bar. And the only way with USCIS for you to overcome that bar, that wait, where you have to be out of the country for 10 years, is to be out of the country for 10 years. You can't fix otherwise. And the amazing thing is that if you were in immigration court, this wouldn't be an issue. You'd be able to get your green card right away. So you see that USCIS, the agency, the same government agency who issues green cards, is treating and reading the law a different way than immigration courts. So if you were in immigration court, if you were in removal proceedings, you'd be able to get your green card. But I'm sorry, because you haven't been apprehended by the government, you're not able to. You need to leave the country for 10 years. When we look at where USCIS gets this, there's a discrepancy. Hola, Edith. ¿Cómo está, señora? It's good to see you. There's a discrepancy here because USCIS is reading something into the law that's not there. They're putting words into the law that do not exist. That's why immigration judges say that you can fix here without leaving. Hola, Maria Angulo. ¿Cómo está, mi amiga? It's good to see you. And Edith, estoy feliz que tú está muy bien. Okay. So because there's a discrepancy, we're adding in words. That's what this lawsuit says, that it ain't right. When you scroll through this lawsuit, I'm going to tell you a little bit about what this looks like. So when you see it, you understand it. This is just the cover page. It tells you who is suing who. These people and all the people who are similarly situated are suing the US government. And I always say it's not a good day until you sue the government, because when we are able to sue the government, you know you have a good democracy. Okay, this initial part explains what the problem is. So people are being told they have unlawful presence and they can't adjust status without a waiver. And as we know in the US, if you have the 3 or 10-year bar, you could adjust status if you got a waiver through your US citizen spouse. But if you have a US citizen kid, like the situation I was just describing, if I'm a Mexican woman who's come and gone and I was here for 6 months without permission, I left and I came back, always with permission, always with my tourist visa, I still can't fix through my US citizen son, because you can't get a waiver in the US through a child, through a son or a daughter, okay? This is adding stuff to the law that ought not be there. And the benefit, the development that we have today is an injunction was issued and a stay of removal. And so what this means is, with a stay of removal, is that the court is saying that the government probably isn't going to win, and we don't want to deport someone who ought not wrongly be deported. My prediction is that we're going to see in the next probably 6 to 8 months, the USCIS change its position, and this person will be able to apply for their green card. And here's what I have to say for you. If you've ever been told that you are not able to adjust status in the United States because you need to leave for 10 years, I urge you to send me a message on Facebook. Send me a message on Facebook, because I'm here and I want to talk to you and screen you and tell you whether or not that remains true in light of this decision. Because in light of this decision, that could change everything for hundreds and hundreds and hundreds of people who they want to get their papers, they want to be able to live free in the US, but because of this incorrect way that the law has been treated, they haven't been able to. But your day is changing. And I think that's one of the beautiful things that we see in the development of immigration law, is it ain't over until it's over. Okay? So if this sounds like maybe something that's happened to you, you have a child who's over the age of 21, a US citizen child, and you entered the US with a passport, but you perhaps have unlawful presence, send me a message, because I would love, love, love to be able to help you. And Maria, I know we're waiting on your residency. I still want you to use your advanced parole to go see your mom, and happy birthday to her, because it is safe to go, and I really urge you to do that. But I know that you know that I know that. So folks, if you have any questions, shoot me a message. This is a really complicated issue, but here's the bottom line. If you've ever been told you needed a waiver before, this could change it. So you should make haste. Do not delay. Do not sit on this, because this could be the very beginning of your freedom. This could be the next step in your journey. Thank you so much. See you. Goodbye to everyone who's watching. I appreciate you all, and I hope you have a great night. Shoot me a message.